Who do we have here?
Mr. McCray, Your Honor.
All right. Good morning, Mr. McCray. Mr. McCray, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On April 3rd, 2024, the officer was dispatched to an apartment in Harris County, Texas, in response to an assault call. The complainant is the defendant's daughter. The complainant is the defendant's daughter's boyfriend, and the complainant was staying with her daughter, and when she got on the phone call from her boyfriend. The defendant got upset and said he was tired of this bitch's voice, referring to the complainant. The defendant got in the complainant's face and punched her in the lip, causing pain, and for her tooth to fall out. The complainant was treated by EMS.
Mr. McCray, I'm going to find that there's probably.
That's not just assault, that's assault with dental consequences. When someone loses a tooth during an argument, it's a serious bodily injury case. What do you think, rage or pattern? Drop it in the comments.
Probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. Do you understand? In fact, I'm going to send you right now for a drug test. I want to know what, if anything, is in your system. I'm also ordering you not to be in possession of weapons and not to have contact with the complaining witness in this case. Do you understand?
But they want to write an affidavit. Can they do that?
I don't answer questions, Mr. McCray. I'm telling you what the expectation of is while you are in this court. You can either abide by the expectation or you can, the other thing is going to happen. Do you understand? Are you high right now?
No.
Be careful. I'm sending you for a drug test. If you fail to go take the drug test, if you fail to come back, you know what's going to happen. Just take a seat for me and then we'll get you. I'm sending you for a drug and alcohol test right now. Do you understand? Take a seat for me, sir. Top of page 11. Sorry, I want to know how we're, come up, Ms. Imam.
You just met, so we
Okay.
haven't had a chance to.
I'll give you a little bit of time, but
My understanding is procedurally what has happened is she was on a pretrial diversion.
correct.
Her previous lawyer has passed away.
Mhm.
The state has rescinded or terminated the pretrial diversion that she was on. I've had a chance to kind of go through a little bit of in the way of discovery. She wants to move forward and try to figure out what we're doing with the case, needs me to do that. By way of background, she works as a pharmacy technician at Walgreens, as a student in college. Quite a bit of mitigating stuff. I need to really have some time to dissect it all.
Is she using while she's on bond? Was that the issue?
Let me see, Judge. I'm not sure why Nathan.
Shatoria, tell me about Miss Imam, huh?
It looks like she had continuous violation.
Did you catch that sudden tone shift? The judge's "are you high right now" wasn't small talk. Sending someone for a drug test mid-hearing? That's courtroom heat.
Her device after being placed on a zero tolerance. She had a pattern of failing to report the visits. She failed to complete SOP. She failed to maintain the alcohol monitoring device. I don't see any. The violations on the device were skip tests.
And Judge, I think there was some times where there were some missed tests. I don't know that.
So I'll give you time,
Yes, Judge.
okay? I'm putting a scram on your ankle now, so I know that you're not consuming alcohol. And if I find that you consume alcohol, or if I find that you're consuming illegal drugs, it's really, really not going to go well for you.
Yes, sir.
Do you understand?
Yes, sir.
Yes.
Does she have a Texas driver license?
Wait, let me talk to me.
Just,
You run it, Judge.
Yes, she
It
does.
hasn't been run. Okay. You're running it? Okay.
so let's do this. I'd like her to get a scram today.
Yes.
I'm also going to send her for a drug test because I want to know what, if anything, is in her system. We'll sit you off 2 weeks for you guys to decide what you guys want to do. Okay? Get what you need. Your case is 530 days old. It's time to decide what we're going to do. It looks like they've already kicked you out of the program. I don't know if they're going to relent and let you back in. I don't know. But I'm going to tell you now, let's just cross that bridge when we get there, but
What I would like is if in maybe 60 days or something like that, if things are going well on the scram device, maybe come back in and revisit and get a.
I don't, well, no. I don't know if I'm going to keep the case open 60 days. It's 525
Fair enough.
days, you know? I mean, I'll give you some time,
I just
but
need to make sure all the
Judge, we
discoveries.
do have an offer in on this case as well.
what is
We put in
it?
an offer, a time served.
Okay, so there's an offer. So when we come back, you know, I'll give you 2 to 3 weeks, but when we come back, you need to either accept the plea bargain from the state or I'm going to set your case for trial. If I find that you're using or doing anything to violate the law while you're on bond, now I'm going to put you in jail. Do you understand?
Yes.
That's it. You're not allowed to drive.
This defense is pulling out Hardin versus State, a real legal curveball. Could failure to stay in one lane be too weak for a stop? Big question. Should more traffic stops be challenged like this?
Unless you have liability insurance in your name. If you do not have car insurance, do not drive. Do you understand? Okay. So we'll give you 3 weeks,
Yes.
Mr. Garris, but at that time, when you come back,
That it or I will
either accept or if you're going to provide mitigating evidence to the state
try to get back in the public.
before that day, so we know,
I will do that in advance.
please.
Yes.
Okay, Ms. Simon. All
you,
right,
Judge.
so I'm going to put the devices on her today. She gets a test today and all fees waived.
Thank you.
Judge, my apologies, I misunderstood. Could you please go over those conditions again for me?
I want to send her for a drug test now,
Yes, Judge.
and I'd like to put a scram on her ankle now today as well.
Yes, Judge.
Okay? We'll set the case. I'm sorry?
Did you want random UAs as well?
Well, no, I just want to know if she's clean now or not. And then in 3 weeks, this case is
Yes, Judge.
one way or the other.
Yes.
And then, okay?
Thank you, Judge.
All right, guys. Working. Good morning, Mr. Anderson. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane while traveling west on Jester Boulevard. The officer observed the defendant constantly veering out of the lane and going into the second lane. The officer observed the defendant to be the driver and sole occupant of the vehicle, and while speaking to the defendant, the officer observed a strong odor of an alcoholic beverage and bloodshot eyes. The defendant was struggling while exiting the car and was swaying back and forth while speaking to the officer. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused and a blood search warrant was drawn and executed.
Your Honor, may I make argument, Judge? Thank you, Judge. The sole reason for the stop in this case was failure to maintain a single lane. Most recent case law on this is Hardin v. State, and in that case, it overturned even Lemming, and they went as far to say is that failure to maintain a single lane is not probable cause for a stop.
Well, I get it, right? You have to dictate more than just saying failure to maintain.
Yeah,
You have to have provide.
a danger to another vehicle. There's other vehicles around. And this is on TC Jester Boulevard, a very sparse road at night. And this
So what were the indicative facts?
I'm opening the offense report.
Yes, Your Honor, we're looking at the offense report.
I mean, obviously, we don't have any body cam, dash cam, so I'm not,
Right, but this is just a mere probable cause. I need enough of a statement from the officer in the DIMS saying how he justified pulling the car over in light of failure to maintain a single lane. The weaving statute. I mean, do you need a bit of time? If you want to reconvene in like maybe 30
Yes,
minutes,
Judge.
it's fine.
My offense report's not running for some reason, so.
If we may have a little bit more time.
Mr. Saman, do you have somewhere else to go?
I have Fort Bend to go to. Can I go to Fort
Well,
Bend?
that's going to take hours. If you want to, yes, because you can always zoom in. I have Zoom for you.
I'll wait.
So perhaps maybe, 15 minutes, give them time to look at the OR.
No problem.
Just take a seat from Mr. Anderson. We'll come back.
This way.
For now, we'll have you sign a reset.